The journey has been long and the path difficult, but the final resolution is finally within your reach at the end of the road. Stay with us as we piece together the last bit of the puzzle. Hit subscribe now and be there for the most important ending.
They thought I was confused. They thought 63 years of building something from nothing had finally caught up with me, that my mind had gone soft the way my hands had gone rough. They whispered about it at the dinner table when they thought I was watching the game. My son, my daughter-in-law, and the man she had been meeting every Tuesday for the past 2 years while my son looked the other way. I heard everything. My name is not important. What I built is. 41 years ago, I started a residential construction company out of a single pickup truck and a toolbox my father left me when he died. I poured concrete in 100-degree Texas heat. I framed houses in January with cracked fingers and a thermos of black coffee. I built the company the way I built every house, one nail at a time. No shortcuts, no partners, no investors who would someday think they owned a piece of what I bled for. By the time I turned 55, we had completed over 400 homes across 3 counties. The company was worth more than I ever allowed myself to say out loud. My wife passed 8 years ago. Pancreatic cancer. 14 weeks from diagnosis to the day I sat alone in a hospital room and held her hand while the monitor went flat. After that, my son was all I had. Mon son, Daniel. I gave him everything after she died. Not the company. I kept working because work was the only thing that made mornings bearable, but everything else. My time. My attention. My trust. When he married his wife Claire, I welcomed her the way I had always wanted a daughter. I bought them the land they built their house on. I co-signed when the bank hesitated. I showed up every Thanksgiving, every Christmas, every birthday, because family was the only word that still meant something to me after I lost his mother. I should have paid closer attention to what that word meant to them. It started small, the way these things always do. Daniel began asking about the business structure. Casual questions at first: how the accounts were organized, whether I had updated my estate documents, who handled the bookkeeping. I answered honestly because I had nothing to hide and he was my son. Then the questions became suggestions. He thought I should consider stepping back. He thought the stress was affecting my health. He mentioned, more than once, that a man my age shouldn't be carrying so much alone. I was 63. I ran 4 miles every morning. My doctor told me at my last physical that my blood work looked like a 50-year-old's. But I listened to my son because that is what fathers do, and I told myself the concern was genuine. Then I noticed the file. I had come home early from a site visit one afternoon, a framing issue I resolved in under an hour, and Daniel's car was in my driveway. He still had a key. I had never asked for it back. When I walked in through the side door, he was sitting at my desk in the study, not the kitchen table where he usually waited, but my desk, with my file cabinet open and papers spread in front of him. He closed the drawer fast when he heard me. He said he had just stopped by to drop off some paperwork Claire needed signed. He was smiling when he said it. The drawer he had closed contained my original partnership dissolution documents, my current operating agreement, and the folder where I kept the most recent business valuations. I smiled back and said nothing. That night, after he left, I sat in my study for a long time. I am not a man who jumps to conclusions. I build things. I measure twice. I do not cut until I am certain. So before I allowed myself to believe what I suspected, I decided to watch. I have a friend named Walter. We grew up on the same street. He spent 30 years as an investigator for an insurance company before he retired, and he still has more patience and more contacts than anyone I have ever known. I called him the next morning and told him what I had seen and what I suspected. He listened without interrupting, which is one of the things I have always respected about him. When I finished, he said, "Give me 2 weeks." It took him 10 days. What Walter brought me was not what I expected, even though part of me had braced for something. The documents he laid on my kitchen table showed that Daniel, using a limited power of attorney I had signed 3 years earlier, for a routine real estate transaction, one I had forgotten about entirely, had made inquiries with 2 separate law firms about the process for contesting a BA, business owner's mental competency. He had not filed anything, not yet, but he had asked detailed questions about what evidence would be required, what medical documentation would support a petition, and how quickly assets could be placed under a conservatorship once a petition was granted. He was building a case against me, his own father, and Claire's name appeared in the billing records of one of those law firms, not as a spouse, as a separate client with a separate matter, a consultation about asset protection in the event of a significant inheritance. I set the papers down. I looked out my kitchen window at the oak tree I had planted the year Daniel was born. Then I called Walter back and told him I needed more. What came next was worse. Claire had been involved with a man named Greg for at least 22 months. Walter had photographs, hotel records, and a series of financial transfers, small amounts, under reporting thresholds from a joint account she shared with Daniel into a private account, registered in her name only. Greg was a commercial real estate broker. He had his own money. This was not about Greg's money. Walter believed, and I came to agree, that Claire had seen my business valuation in those files. Daniel had been reading, and decided that whatever Daniel stood to inherit needed to arrive before I had time to change anything. My son either knew and was participating, or he was being used by his own wife and was too blind to see it. I have spent more hours than I can count, wondering which one was true. I am still not entirely sure, but it did not matter. What mattered was what they planned to do with what they knew. 3 weeks after Walter gave me his report, Daniel called me and said he wanted to take me to lunch, just the two of us. He said there was something he needed to discuss. We went to a barbecue place we had gone to since he was a teenager. He ordered the brisket. He waited until we were halfway through the meal before he said, quietly, that he had been talking to some people and he was worried about me. He said I seemed forgetful lately. He mentioned a conversation we'd had in which I had supposedly confused the name of a supplier, a conversation I had no memory of because it had not happened the way he described it. He said Claire had noticed it too. He said maybe it was time to think about easing me out of day-to-day operations for my own sake, and perhaps formalizing things so there was a clear plan if my condition, he used that word, condition, progressed. I set down my fork. I looked at my son across the table. He looked back at me with what I can only describe as practiced concern, the kind you rehearse. I told him I appreciated his worry. I told him I would think about everything he said. I paid the check. Then I called my attorney. Her name is Margaret, and she has handled my business affairs for 19 years. I told her everything. She listened the way good attorneys listen, quietly, and with a legal pad. When I finished, she said we needed to move carefully, and we needed to move soon, because the power of attorney Daniel had been using had not yet expired. We spent 3 hours that afternoon restructuring everything. We revoked the power of attorney that same day. We updated my will, my operating agreement, and my healthcare directive. We documented, in writing, with 2 witnesses and a notary, a full account of my cognitive assessment, including a voluntary neurological evaluation. Margaret suggested I complete immediately, which I scheduled for the following week. I scored in the 93rd percentile for my age group. The neurologist said my memory and executive function were exceptional. He put that in writing. Margaret kept copies of everything. I kept copies of everything. And Walter, because Walter had been doing this for 30 years and understood something about people who feel cornered, suggested one more step. He suggested I wait, not forever, just long enough to let them make their move, because people who have invested this much in a plan rarely abandon it. They press forward, and when they press forward, they leave evidence. Daniel filed the competency petition 6 weeks later. I found out on a Monday morning when Margaret called me. The petition cited concerns about my memory, my judgment, and my ability to manage financial affairs. It included a signed statement from Claire describing 2 incidents she claimed to have witnessed personally. It included a statement from Daniel describing the conversation at the barbecue restaurant, his version of it. It named Daniel as the proposed conservator of my estate and business assets, pending a court evaluation. I sat in my truck in the parking lot of one of my job sites and read the documents Margaret had emailed me. Around me, I could hear my crew working. Nail guns, a circular saw, the sounds I had built my life around for 40 years. I read every page twice. Then I called Margaret and told her we were ready. The hearing was set for a Thursday morning at the county courthouse. I arrived early. I wore a charcoal suit I had bought for my wife's funeral and had not worn since, not because I was performing anything, but because I had decided that morning, standing in front of my bathroom mirror, that I was walking in there as exactly who I was. A man who built 400 homes. A man who ran 4 miles that morning before the sun came up. A man who was not confused and never had been. Margaret met me in the hallway. Walter was there too, sitting quietly on a bench near the door, which is where he had agreed to be if I needed him. Daniel and Claire arrived together. Greg was not in the courtroom, which surprised me briefly before it didn't. Claire was dressed formally. Daniel would not meet my eyes when they walked past. I watched him look at the floor and I felt something I did not expect. Not anger, not satisfaction, but a kind of grief, so old and heavy, it had no sharp edges left. I had loved this boy. I had coached his little league team. I had taught him to frame a wall and read a blueprint. I had held him in the hospital parking lot and wept into his shoulder the night his mother died. And he had looked at everything I built and seen only what he could take. The judge was a woman in her late 50s named Judge Patricia Holloway. She had a reputation in this county for not tolerating anything she considered a waste of the court's time. Daniel's attorney presented first. He described a man in cognitive decline. He cited the 2 statements, the barbecue conversation, the general concerns. He spoke for about 20 minutes. Claire nodded at certain points. Daniel kept his hands folded on the table. Then Margaret stood up. She submitted the neurological evaluation first, 93rd percentile. The judge read it without expression and set it aside. Then Margaret submitted the revoked power of attorney, time-stamped 6 weeks before the petition was filed, which demonstrated, she said, that I had been fully aware of what was happening and had taken decisive legal action before Daniel had made his move. Then she submitted Walter's investigative report, which documented the law firm consultations, the timelines, the financial transfers, and the hotel records. The judge looked up from the report. Daniel's attorney started to object to the investigative materials. Judge Holloway told him to sit down. She looked at Daniel, then at Claire. She looked at them for a long moment, in the way that judges look at people when they have already made up their mind, but are deciding how to say it. Then she looked at me. She asked me to stand. She asked me 3 questions directly. What was the current assessed value of my company? What was the name of the statute under which the original power of attorney had been drafted? What was the date I had it revoked? And what were the names of the witnesses? I answered all 3 without hesitation. She nodded slowly and told me to sit down. She denied the petition, completely, in full, with a formal note entered into the record that the filing appeared to have been made in bad faith and that she was referring the matter to the state bar for a review of the attorney who signed off on Claire's fraudulent witness statement. Claire said something under her breath. I couldn't hear what it was. Daniel said nothing. He just sat there with his hands still folded on the table, and the only change I could see in him was that his jaw had gone tight. Margaret immediately filed a civil suit for financial elder abuse under Texas law, citing the unauthorized use of the power of attorney to access confidential business records and the attempted fraudulent conservatorship. The transfers from Claire's joint account became part of a separate action. Walter's documentation went to the district attorney's office 3 days later. I will not stand here and tell you I felt joy in that courtroom. What I felt was something quieter than that. The weight of a thing that had been pressing on my chest for months, lifting all at once, not because I had won, but because I had not allowed myself to become what they decided I was. A confused old man. Un obstacle. A signature en un document. I am not a man who gives speeches. So I will just tell you what happened after. Daniel called me 4 days after the hearing. He said he was sorry. He said Claire had pushed him into it, that he had convinced himself he was doing the right thing. Maybe some part of that was true. I listened to all of it. When he finished, I told him I needed time, and I meant it. We have not spoken since, and I do not know yet what that silence will eventually become. I hope he finds his way back to being the man I raised. But hope is not the same as trust, and trust, once broken the way this was broken, is not rebuilt with a phone call. Claire and Greg left the county before the civil suit went to trial. The transfers were repaid as part of a settlement. The bar complaint against her attorney resulted in a formal censure and a 2-year probation. Daniel was removed from my will and from any position in my company. He received nothing. My company is still mine. I ran a 4-mile loop this morning. The oak tree in my front yard is taller than my house now. I planted it the year my son was born, in a yard I built a life around, in a town I poured everything into, and it is still standing. Suanwi, if you are watching this and you built something with your hands, with your years, with the parts of yourself you can never get back, do not let anyone convince you that age makes you less. Do not let the people you trusted most turn your love into a liability. Measure twice, watch carefully, and when it is time to act, act without hesitation and without apology. That is all I know. That is enough.